You must show up at the date and time listed on your temporary restraining order so that the matter can be heard by a judge. You are the plaintiff, and the abuser is the defendant. If you are unrepresented or pro se, go to court and have a seat in the waiting area outside the courtroom where your matter will be heard. Some courts have a separate waiting area where domestic violence victims can sit while they wait for their case to be called. Other courts do not have a separate room, so the plaintiff and defendant should take seats as far away from each other as is practical. If you see the defendant, sit in an area away from him. If you feel threatened, tell the nearest sheriff's officer. A different sheriff's officer is assigned to each courtroom. When the sheriff's officer for your courtroom comes out to ask who is present for that judge, you need to check in by letting the sheriff's officer know that you are present. You want to let the sheriff's officer know if you plan on proceeding with obtaining the final restraining order, how many witnesses you have, and also if you need an interpreter. If English is not your native language, you should ask for an interpreter. If you need an interpreter other than Spanish, it is a good idea to call the court to request one beforehand. Testifying in a courtroom is a stressful experience for most people, and even those who may be able to speak English in other settings will find it difficult to find the right words when under the pressure of a court hearing. After checking in, you can retake your seat. You can spend the time reviewing your case. If there is nothing to review, spend the time trying to relax. On the day of the final hearing, a couple of things can happen. Either party may show up and ask for an adjournment, which is simply extra time to better prepare, find an attorney, or request an interpreter. If this is the first court date for the matter, an adjournment will likely be granted. If both you and the defendant show up, the full hearing may proceed. You should always assume that the case will proceed on the final hearing date, and you should therefore arrive on time and plan to be in court all day. Or, one party may fail to show up on the date for the final hearing. If this happens, the matter may be adjourned for this reason as well. However, if you are the plaintiff and you fail to appear for your final hearing, you should know that the court may dismiss your temporary restraining order. If you, the plaintiff, appear and the defendant does not appear, the judge may either adjourn the matter or allow you to proceed with the presentation of your case. Once you are called in for your case by the sheriff's officer, you will be seated at a table on one side of the courtroom, and the defendant will be seated at another table. If either of you have an attorney present, the attorneys will be seated with you at your tables. If an interpreter is needed, he or she will sit in between the two tables or with the party for whom the interpreter is needed. When the case begins, if present, the attorneys will introduce themselves and their clients to the court. You and the defendant will then be asked to swear or affirm that everything you say is the truth. The hearing will then begin. You, the plaintiff, as the party bringing the lawsuit, will present your case first. If you have an attorney, your attorney will ask you questions and you will answer them. If you do not have an attorney, the judge will ask you the questions. This is called direct examination. You will be given the opportunity to testify, tell your side of the story, and then present any relevant evidence and other witnesses to the domestic violence incident or incidents. The defendant or his attorney may object to any testimony or evidence that they see as inappropriate. The judge will then either sustain the objection, preventing the speaker from testifying or presenting evidence about a certain aspect of the case, or overrule the objection, permitting the witness to continue testifying and presenting evidence. Remember that if you hear either attorney object to a question or answer, you should stop talking and listen to what the judge decides. The judge will tell you whether or not you may continue to testify. During a final restraining order hearing, you have to prove certain elements by what is called a preponderance of the evidence. Preponderance of the evidence simply means that your version of events is more likely than not to have occurred than the defendant's version. There are 3 things that you need to prove to meet this standard. First, you need to prove to the court that you are in a relationship recognized by the Prevention of Domestic Violence Act. How do you know the defendant? Your relationship with the defendant must fit a certain criteria. Were you and the defendant married? Are you married now? Did or do you live together? Do you share a child? Were or are you in a dating relationship? Secondly, you must prove to the court that an act of domestic violence was committed against you. This act must be one of the 19 crimes that you can see on the first page of your temporary restraining order. This is also the current incident that is captioned on the first page of your temporary restraining order above those 19 listed crimes. The judge will decide if a current act of domestic violence has been committed against you by considering a history of domestic violence that was committed against you. The final element you need to prove is that you are in need of a final restraining order. That is, without a final restraining order, there will be immediate danger to your person or property. This element is necessary because the law says that one single act of domestic violence may not be enough to result in a final restraining order.
If you need legal advice or representation, you can see if you are eligible for our services by calling 1-888-LSNJ-LAW or completing our online intake at www.lsnjlawhotline.org.